and the state is telling me that they can proceed with their case, I don't understand why I should be following this agreement. So if there is something, and I've been a defense attorney and I've been a prosecutor, and sometimes I realize that you all know more about the case than a judge would know. So is there a reason why he should not be going to a jury trial for and I guess this started out as a continuous. Is there a reason why he should not be going to a jury trial? And if the jury finds him guilty, they find him guilty. If they find him not guilty, they find him not guilty. Right, the court is calling 2022 CR 8955, State of Texas versus Christopher Garza. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
For the
I'm appearing for Robert Ariano, attorney of record for the firm, and representing Christopher Garza.
And are you Mr. Garza?
Yes, ma'am.
All right. So according to the plea bargaining agreement, the state waived count 2 and is proceeding on count 1. And the state is recommending deferred adjudication. Is that correct?
Correct. We proceeded under count 1. We proceeded on the lesser included aggravated sexual assault of a child.
All right. Is there a reason there's an offer for deferred adjudication in this case?
Your Honor, this is a case where the victim in this case has had several mental health episodes. And when we met with the child, she very clearly is still very emotionally devastated, as she should be, from these allegations. And based on our interactions with her and some thoughts of harming herself and other anxiety and other issues, it's the state's opinion that it is in her best interest and in the state's case to resolve this matter with a plea agreement. Having been in this unit, I know that the sex offender unit is very intensive supervision. And with the deferred, we do have the ability to sentence him up to 99 years if he does not abide by the conditions.
Right. So you are saying that you would not be able to go forward with trial if the court were not to follow this agreement? Is that what the state is saying?
No, Your Honor. I think we could go forward with trial, Your Honor, but it would be
because I'm reading the PSI report. As you all know, I read all the PSI reports, and the family wants him underneath the prison.
Right. We spoke to the family, Your Honor. They understood the plea agreement. We've spoken to them since the PSI report as well. They understand the plea agreement. They were agreeable to it. I think when the PSI officer spoke with them, it was more of a, what would you like? And not they didn't quite understand. And of course, with the gravity of these charges, it definitely is it is a common opinion that he should be in prison, Your Honor. But
so, I mean, if he should be in prison and the state is telling me that they can proceed with their case, I don't understand why I should be following this agreement. So if there is something, and I've been a defense attorney and I've been a prosecutor, and sometimes I realize that you all know more about the case than a judge would know. So is there a reason why he should not be going to a jury trial for and I guess this started out as a continuous. Is there a reason why he should not be going to a jury trial? And if the jury finds him guilty, they find him guilty. If they find him not guilty, they find him not guilty. So if there is an issue that you all know in your plea negotiations, and I know that plea negotiations are confidential, if there's something in your plea agreement that would make me rethink and say, yes, judge, you should accept this plea bargain agreement, then you can just say on the record, Your Honor, there's something with our plea negotiations, and we would hope that you would accept this agreement. Otherwise, I don't see why I should follow this agreement.
I can Your Honor, I was not at the this is so bad. At the plea in January. I believe Judge Nahara heard the plea and accepted the plea. I am reading notes from the attorney that was there, and it does appear as though there were several issues going back and forth, some discrepancies, I believe, in the interviews, the forensic interviews, and credibility issues. There's potentially another suspect that has not been identified. And so in looking at it, I would agree with the court. However, my client is fully accepting what this means to him. I've reviewed the Chapter 62 registration requirements with him. I've spoken with his wife. His wife is here in the courtroom. He does have a place to go when he is done. He has a job. He's been in security for 11 years. He has stability. He wants the opportunity to go undeferred so that he can prove and redeem himself. There are past family issues with the complainant's side of the family, but I'm not here to retract or recant his plea. And because I know the court has already accepted his plea, at least the plea of guilty to this case, I certainly don't want to change that. And I've advised my client not to change that. But I do think that there is sufficient reason for the court to follow the agreement for the deferred. And I would agree with the state that he is aware of what would happen should he violate, what could potentially happen should he violate his conditions of probation. He has thoroughly reviewed the Chapter 62 registration requirements, and again is prepared to do that. However, I would say that if the court doesn't find it in his interest, or in the community's interest to put him on deferred, I don't know if there's a mechanism by which we could withdraw the plea and go to
Oh,
trial.
no.
or-
What would end up happening is just, I would not accept the plea. I would reject your plea.
Okay.
But based upon what defense counsel is telling me and what state is telling me, as a former family violence prosecutor, I understand that there may be negotiation issues as to why an offer is made in this type of case. So I'll follow your plea bargain agreement, sentence you to 10 years deferred adjudication. There's to be no unsupervised contact with minors, no contact with the complainants or the complainant's family. Chapter 62 registration, regular reporting by Zoom or in person, regular UAs. You're going to be on the sex offender caseload. I'm going to want field visits at least 1 month. At least once a month. And probation, if you want to count the field visits as reporting, you can. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Probation, is there anything else he needs? Regular UAs. All right, is there anything else you need from the court?
Your Honor, with regard to the no contact with minors,
No, I said no unsupervised contact.
okay, so he can move home.
He can have no unsupervised contact with his biological children, but then there's also no contact with minors.
I understand that. I just want to make sure because I have dealt with this in prior cases where probation reads it entirely different and then they will not allow them access to their biological children.
And I'm sure Child Protective Services should be involved.
They already have, Your Honor, and ruled out everything other than this complainant.
All right, and probation, just do compliance with CPS if applicable. If CPS has closed their case, then they're closed their case. Showing you what's entitled trial court certificate, go around. Why do people think they can reach through and their
Well,
arms are
because,
that
Your Honor,
long.
it's- we don't want to walk around a barrier either. Your Honor.
All
You put
right.
up a barrier and I'm gonna follow it.
Thank you. You're the only person who wants to follow that. All right. I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right. Good luck to you.
Thank you, ma'am.
Thank you, Your Honor.
The courtroom is tense as Christopher Garza stands before Judge Stephanie Boyd, hoping for a deal that will keep him out of prison. The charge is serious, continuous sexual abuse of a child. A jury trial could mean a life sentence. But the prosecution and defense have worked out an agreement, a 10-year deferred adjudication probation, meaning if he follows the rules, he won't have a final conviction. But Judge Boyd is not one to simply rubber stamp a deal. She questions the prosecutor, asking why such a lenient offer is on the table for such a grave crime. The prosecutor's response sends a ripple through the courtroom. The family wants him underneath the prison, she admits, before adding that the victim is emotionally devastated. Judge Boyd, a former family violence prosecutor herself, is visibly troubled. I don't understand why I should follow this agreement, she states, her voice firm with authority. The defense attorney quickly intervenes, painting a picture of a man ready to redeem himself. He cites discrepancies in interviews and hints at another suspect to create reasonable doubt. He pleads for the opportunity for his client to prove himself, highlighting his job and family support. The suspense is palpable. Will Judge Boyd accept the plea, or will she force a risky trial? Then, in an unexpected turn, Judge Boyd makes her decision. Citing her own experience and the delicate nature of plea negotiations, she decides to follow the agreement. The decision changed everything for Garza. He is given one last chance, but it comes with strict, humiliating conditions. He must register as a sex offender for life, have no unsupervised contact with any minors, including his own biological children, and submit to monthly field visits from probation. As Judge Boyd lays out the harsh terms, she shocks the court with her final warning, making it clear that this is no ordinary probation. One mistake, and he faces prison for up to 99 years. The defendant, realizing the sword hanging over his head, quietly accepts, but the judge's skepticism lingers, proving that in her courtroom, there are no second chances without a price.